Welcome to this edition of Real World Employment Law, where we talk about real cases and issues impacting the workplace. I'm Declan Leonard. I head up the employment law practice here at Berenzweig Leonard.
And I'm Elizabeth Payne Madalena. I'm a senior associate here at Berenzweig Leonard.
And Liz, it's great to have you in here talking about the case that we're going to talk about today. It's true that you're a trial lawyer, right?
Yes, that's true. Before I came here, I handled a few jury trials, we'll say, and then I'm going to continue working on litigation here, which I'm really excited to do.
Perfect. And this topic will be right up your alley. So what we're going to talk about today is we're going to talk about, I'm going to use the legal phrase first, which are called forum selection clauses. And before everybody runs to hit the off button on this podcast, I want to tell you to stick with us because this is actually one that is incredibly relevant, not only in the employment context, but also in the business world.
Yes, that's right. My understanding is that you're going to see these in contracts, not just for employment, like you mentioned, but even those apps on your phone that you get all those terms of services for, you don't actually read. Those oftentimes even have forum selection clauses, so they're really everywhere now.
Yeah, and in a nutshell, a forum selection clause, it's really if there's a dispute between two parties in a contract, where does one of the parties sue if they need to file suit? And you usually find these at the end. You hear people say, oh, that's the boilerplate at the end of a contract. The boilerplate often, and we know this as litigators and in employment law and in business law, that actually becomes pretty important.
Yes. And why is it really important in the employment context?
Well, so here's one of the reasons is, employees are spread out sometimes all over the place. And so it's very important for companies, if they want to have some predictability, if they want to be able to direct where a case is going to be brought. I mean, sometimes, litigation is inevitable in the employment context. It's a lot of what we do here. The company wants to know, where am I going to be sued? The case that we're going to be talking about today is an interesting one because it's got a fact pattern that I think really sort of highlights this issue of where somebody could be sued or where they can sue. So let's talk a little bit about this particular case that emanated out of New York.
Yeah, sure. So the case is, and I'm probably going to massacre this person's name, Declan versus the American University of Beirut. In this case, the plaintiff, he's a U.S. citizen. He was living in New York when the lawsuit was filed. The American University of Beirut, that's actually a U.S. corporation. It's incorporated in New York. It has a business office in New York. And in this context, the plaintiff was an employee of the American University of Beirut and taught classes in Beirut.
Okay, so companies headquartered or at least has an office and was incorporated in New York. This is a New York person. It's a U.S. citizen. But because it's the American University of Beirut, of course, he's going to actually be performing the services over there. So what happened? Why do we care?
So what happened here was, a long story short, is this professor, the plaintiff, was fired from his job after there were some allegations against him, and he disagreed with how that was handled, so he filed a lawsuit, and he filed it in New York. And
that makes sense. I mean, that's where he lived, that's where they had an office, and that was the United States, so I understand that.
Right. And what happened, though, is the company, the university, essentially said, hey, not so fast. We have this forum selection clause, this language in your offer letter that you signed when you were employed that said you have to file all the lawsuits for your employment in Lebanon.
Ah, I see. So, in other words, when the employee started, the employee signed, an employment agreement of some sort, whether there's an offer letter, but they're all contractual documents. Mm-hmm. It probably had his salary in there. It probably had all of his benefits and everything like that. But at the end of it, it said any disputes have to be brought in Beirut. Is that correct?
Right. And the language was actually really specific. It said that Beirut and Lebanon was the exclusive jurisdiction, that any and all possible agreements that were, or disagreements or disputes, would all have to fall under these courts, no matter what.
So he brought suit in New York, and what did the university do?
The university filed a motion for forum nonconveniens, which is a fancy way of saying wrong place, got to sue me somewhere else, and said that they need to be sued in Lebanon.
But this professor is no longer working there, was removed from Beirut, and is now living in New York. so can't readily walk down the street to the Beirut Circuit Court and file this. So the court is faced with this dilemma. The magic question always with real-world employment law, who won?
So the university won. The court sided with them, yeah.
University said, this case can't be raised in New York.
Yes, they said he signed this agreement, and this was a very clear forum selection clause, and the court said, you're right. And they said you have to sue in New York, or in Lebanon. So even though he was now living in New York, that's halfway across the world, that's where he has to sue now. That's the agreement. That's what it said, and the court said we're going to uphold that.
Okay, even though some of the causes of action might not even be recognized in a court in Beirut, civil rights acts and things like that. The U.S. has probably a lot more progressive laws than perhaps some of these places in the Middle East.
Yeah, no, and that's actually something the plaintiff raised in this case, and he said, look, Beirut, Lebanon doesn't even have a legal premise for forum selection clauses, and also they don't have these civil rights kinds of laws that I'm suing under, sexual harassment laws, and the court said, well, they have something close enough for those civil rights actions, and close enough works. It's adequate. It doesn't have to be the exact same. The court also said when it came to that, the argument that there's no forum selection clause is recognized under Lebanese law, there's really no legal action for that there. Court said, well, that's fine. They can apply what we have already ruled and said that it has to be in Lebanon, and that's what they can just apply there. Okay.
So, some would say potentially a pretty harsh outcome for this particular professor in trying to remedy its rights. For clients that we deal with here at Berenzweig Leonard on a more typical basis where we're not seeing these international choice of law, talk about how what they should be looking for.
So for clients that we may have that have oftentimes, especially government contractors, you might have offices or work sites spread across the country. You may even have, depending on the kind of work you do, contractors working overseas or employees working overseas on deployments. These kinds of clauses will help protect you and make sure that you're going to be sued in the Commonwealth of Virginia where your headquarters are, no matter where your employee is working from. And that's what it does, is it helps protect insurers and helps keep down those costs of litigation too, because it gets really expensive, especially if you're traveling and flying, all over the place because of a lawsuit that could be in Afghanistan or something like that.
Yeah, and of course, putting in a plug-in for our local federal court here, the Rocket Docket, which is located here in Alexandria. They call it the Eastern District of Virginia. It's really one of the most efficient. It certainly is one of the quickest courts, and we're very familiar with it. We are very comfortable litigating there, but for a lot of our clients, it really is a nice court from a business standpoint to have in your backyard.
Yes, definitely. And again, that also helps keep costs down of litigation because you're able to get things moving that much more quickly.
Yeah. So bottom line sounds to me, a contract is a contract is a contract, and you've got to read these things. I mean, is that correct?
Right. In fact, the court did say, look, the plaintiff had an opportunity to negotiate the terms of the foreign selection clause because he had the opportunity to read and review it, and if he had had a concern, he could have raised it. And so it is important to read through these contracts and make sure that if you have a concern, you say something. Silence can be used to kind of waive those rights.
Perfect. Okay, good. Well, listen, I think that this was a good discussion. It's a very important discussion, Liz, in terms of our business clients and executives as they are looking at their contracts, to read it all the way through and not get past what your pay is going to be and what your benefits are going to be, but go all the way to the end and know that, listen, sometimes things go south. Let's have some predictability as to where we're going to be in terms of where to sue and be sued.
Right, and it's also something that you want to make sure you talk to attorneys about if you're trying to draft one of these kinds of clauses, and make sure that it's going to be a forum selection clause like the one here that the court upheld, that it has the right kind of language in there that courts favor, to make sure that you're not going to end up putting something in that wouldn't be upheld.
Perfect. Well, listen, I hope everybody found this edition of Real World Employment Law helpful, useful in their running of their business, and we're going to keep these coming. So thanks so much.
Thank you.